Thanks very much for that, Isabel. That's a very kind introduction. And hi, everyone, and welcome to this last speed dating session from Ius Laboris this year on criminal records checks and vetting. Those of you that have been to the session before will, or a session over the last year or so, will know how it works. I'm going to give just a general introduction to criminal record checks and vetting and some of the data and workplace issues. And then I'm going to run through all our wonderful panelists who are going to give their views from their particular countries. And hopefully at the end of the session, if you won't know everything about criminal records checks and vetting, you'll have a good idea of the basic issues that we have to deal with and some of the nuances in the countries. So today, I'm Alex Milner-Smith. We've got Roxana from Romania, Jose Miguel from Spain, Renata from Mexico, Jessica from Germany, Jasper from the Netherlands, and Tiffany from the United States. And we're very grateful to all these speakers for making time. So I'm just going to spend about 10 minutes on an introduction, just setting the scene, talking about some of the European issues. I'm obviously a European lawyer. And then we'll move on to a little scenario that we've created, which we're going to ask all the panelists to give their views on after they've given some of their colour commentary from their particular country. So the reason why we wanted to do this was because it is a perennial question that we get from throughout the whole of the Ius Laboris Alliance, actually all around the world, from clients. And it tends to be, I've framed it rather politely here, we want to do criminal records checks, we want to do background checks, what can we do? It tends to actually be, we're a US parented company, or we're a Singaporean parented company, or a Japan parented company. Other countries obviously are available. And they tend to say, we do this in our particular jurisdiction. And it may involve certain elements of criminal records checks, background checks, and they want to have a general approach across their international business. And so we might get a call in the UK or Germany asking, right, we want to affect our US model, our Japanese model in the UK. Can we do this? And the problem is that, as we'll see today, there are various nuances across the world about both criminal records checks and background checks that do make it quite difficult to have an international approach. These nuances can be minor, which you can ignore, or as we'll see today in some countries, they can be really quite serious, almost total or very restricted prohibitions in terms of running even what we might consider vanilla or basic background checks, let alone criminal checks. And it is a very, very interesting intersection of data and privacy laws, human rights laws, employment laws overlain on that, and then of course different cultures. As we've seen, across all these sessions over the last year, one particular approach that might seem very standard and particularly normal. We've already had a question, which is excellent. I will answer that question a little bit later, just to let me complete my introduction. That is a very interesting question. We've seen that something that might seem vanilla and very standard in one jurisdiction can actually be a completely prohibited approach in another country. So what kind of things are we talking about here? Well, criminal records checks, I'm sure, means the same thing to most people. Just to give you a UK example, in the UK, we have a national body, the Disclosure and Barring Services, that holds everybody's criminal records checks. And at any point, I myself could write to the DBS and ask to see my criminal record. Although I dread to think what it says, but it is actually rather harder for my engager, my employer, or my partners in this case, to actually just go to the DBS. There have to be certain forms that need to be filled in, certain consents need to be given, and there are technically certain restrictions on what can be asked. And I think we'll see that across most jurisdictions. Vetting and background checks can really be as wide or as limited as you want. There's the basic vetting checks that always happens. If someone says they have a degree from the University of X, you probably are allowed to check that someone has that degree from the University of X, and you can check references and so on. But we have seen develop over the last 4 or 5 years far more, one might say insidious, or that's pejorative, I'll just say wider vetting checks being asked for all the way through to a general social media trawl across a whole employees or workers' social media history since they were, however old, 8 years old, depending on how young a child has a phone. And that's a very different thing. You can see the clear link to, right, someone said they have a degree in chemistry from the University of X and they're going to be a chemist. You could see a link there to, we just want to check that they haven't made any social media posts 15 years ago that might cause problems or cause a PR issue for the firm. And so there's a real difference there in how countries approach those kind of checks. And secondly, throughout the process, we're not going to talk about it today. I think next year we might do a session on vendor management and vendor due diligence within the workplace. But there are vendors involved here as well. We have done many pieces of work for clients about particular vetting companies that they engage to actually undertake the vetting on their workers. I won't name any names, but there are some very big players who many people use. There'll be names that all of you recognize. And you need to think about how are you actually going to engage with them from a data perspective and a commercial perspective. But from a data perspective, are they a processor? Are they a controller? Have we done adequate security due diligence on them? Often a lot of these companies are based in the US. Is data being shared with the US and so on? Not the focus today, but we will do a session on that in the near future, I think next year. So that was sort of setting the scene. And I've talked about the intersection of data and privacy laws, human rights and employment law. But obviously from a European perspective, we have writ large the GDPR and the UK GDPR, and then whatever domestic nuances there are in the UK Data Protection Act. In Germany, Jessica will tell us the name at some point of the German domestic legislation, which is a very long piece of legislation. And there might indeed be specific laws in country about vetting. Indeed, in the UK, there's the Rehabilitation of Offenders Act 1974, which you can read at your leisure if you want to go to sleep. But it is rather a crucial law here because it does set out some additional obligations on people who want to see criminal records over and above those in general GDPR. Then, of course, there's human rights. Many is the case where I've done involving employee complaints about vetting, where they have said, actually, it's a breach of the European Convention on Human Rights or the Human Rights Act in the UK. And it's a breach of the Charter of Fundamental Rights and so on. So that's the first intersection we see. And then, of course, there are employment law nuances. In the UK, there are specific rules on what you can do if you actually see a criminal records check. And there's a difference between a spent conviction, where the conviction was not serious and after 10 years it disappears, and an unspent conviction. So if you committed murder, that never leaves your record. Again, we're not going to talk specifically about the employment law issues today, although it might be mentioned, but it's just a useful point that you are looking at seemingly a very simple area. I just want to check that my employee is the right employee for me. And you can actually, if you don't understand the seriousness of some of these laws, get yourself in quite a complex area. And then, of course, as we talked about different cultures, and I think it will be interesting to see the difference between Germany, Mexico, and the US, and so on. And I think it will be interesting to hear from Tiffany, because I think some of our clients sometimes do think in the US, oh, there's absolutely no problem, we can do whatever we like. But we'll hear from Tiffany that actually is not correct. So just the final point and the summary of the European law before I go on to the scenario and then move on to Germany for Jessica's section. Obviously, GDPR, UK GDPR. We know all the rules about lawful basis, proportionality, and privacy notices, but I just want to focus on a couple of areas. One, proportionality and special data. We do come across a great battle with some clients about understanding quite why they need to do the same vetting for a very junior employee who might have access to no confidential information, have no client-facing role, not be in a sensitive area, as they have to do with, I don't know, the key director of a sensitive area who might be involved in fraud prevention or so on. It is the view of data regulators, and indeed it is the view of GDPR, UK GDPR generally, that processing of personal data should of course only be proportionate and necessary. So you can see sometimes when clients say to us, we want to run our full gamut of vetting on an employee who's going to work 3 days a week on our reception desk, and we want to run the same sort of process on our most senior employee, we do often say to them, well, hang on a second, we do have to raise a risk for you that a regulator might view one of that set of processing as disproportionate. And the view tends to be that you should really think about, do we need to do this type of processing for this strata of employees, different type of vetting for this strata, and so on. Now, I know that's difficult because you want to have one size fits all, but proportionality is a key and difficult area that you do need to grapple with. The second point, of course, is special data. When we're thinking of vanilla, boring vetting, checking someone's CV, there's probably no special data involved there. It's just checking, people's addresses, where they went to university, and so on. And a lot of vetting is basic data. And so your lawful basis is probably going to be, legitimate interest, or it might even be necessary for the performance of a contract. There are various schools of thought on that. Where it gets more complicated, of course, is where you are processing special category data, sensitive personal data, if you want to call it that. Now, criminal record data is explicitly called out in GDPR and UK GDPR as special category data. Now, it's not listed in Article 9, it's listed in Article 10, it has its own article, but broadly for the purposes of today, it is listed as special data. And as we've talked about multiple times over the last year or so on these sessions, when you're processing special data, not only just generally do you have to treat it to a higher level, if there was a data breach, it would be more serious. Employers tend to get a bit more energetic if they feel their special data is being processed. You actually also need the secondary lawful basis in Article 9. And of course, the one that's most prominent in relation to the workplace is Article 9(2)(b) in relation to processings necessary for employment law. But it's not always the case that you can process criminal records data because it's necessary for employment law. It's certainly not the case in the UK. For instance, it's only certain roles that actually you can process criminal records data. Working with children, for me as a lawyer, entry to the legal profession, you're allowed to check my criminal record data there. So it's not quite a question of we have a lawful basis because we just need to do it for employment law. That's not always accurate. You then, of course, have consent. But as we know from a European perspective, consent and employment is very difficult. It's actually very difficult for someone to give you valid consent. Can you imagine if it's a recruitment process and you're asking for consent? If they don't give consent, they're probably not going to get the job. So it's highly unlikely a regulator would regard that as valid consent. Now, in the UK, the ICO, the Information Commissioner's Office, our regulator, has actually been quite pragmatic. They've said, we recognise people want to vet criminal record data. And if you can set out why that is necessary with a hand on heart, good faith reason, for instance, you feel you need to protect the public from fraud and criminality and so on, they're probably going to take it at face value that that's okay. But even there, you can see, do we really need to get a criminal records check on a receptionist? It will be different, depends on what company you're in. If you're in a medical company or in a finance company, maybe. But if it's a different company, you can see it's going to be quite difficult to find a lawful basis. And then in terms of vetting, if you are doing social media trawls and someone stupidly has made some kind of appalling comment about their political beliefs, maybe they're a supporter of the British National Party or something, which some may consider racist, and so on. Are you processing data about their political opinions? Again, that's special data. And do you have a lawful basis to do that? So whilst the ICO has been quite flexible, I think we'll see as we move through some of the countries, for some countries, that flexibility isn't necessarily there. And it is really some forms of processing in the vetting sphere are prohibited. So I'm going to go on to Jessica in about 2 minutes, Jessica, but I'll just run through this scenario. And I will just read it to you just in total, because I'm going to get each lawyer is going to go through a little bit of colour commentary on their country in terms of what systems are in place for criminal records checks, what's the culture like, what does the law say, and then they're going to give some comments on this scenario. So a client headquartered in Singapore rings you up and wants some advice. They've been reviewing their recruitment processes and policies and decided they want to make some changes. They want to carry out criminal records checks on all current employees, consultants, temporary staff, regardless of the role or time with the company. They also want to update their recruitment process to carry out vetting before an offer of employment is made. And they want this to encompass the standard checks on qualifications as well as an online trawl, particularly of social media. Client doesn't want any embarrassing future revelations, and they want to gather as much information as possible and don't want to limit it to professional sites or by date or how old the candidate was at any given time. Now, obviously, from the introduction I've given you there, you're seeing where we're going to the issues that raises. And actually, Jessica, just before I do go to you, oops, I'm going to try and answer that question, if you don't mind, Jessica. So I will answer this question. I will just check time. Yep. Are there any privacy issues with completing an OFAC check for all employees globally? We're thinking of doing it in the future, but not too sure if we can yet. If we do this check for a customer that has our staff on site, can we provide the report to the customer or let them know if it comes back as a match for OFAC to explain why the assignment will not go ahead? I have to say, if you could, someone might explain to me what an OFAC check is, but that does raise an issue. One, we're going to talk about whether you can do it globally now, whether I can actually answer that question globally. We've only got 6 jurisdictions here today, but you'll see there will be very different answers across the board. That does raise 2 other interesting issues. We are seeing more and more for some of our clients that some of their clients, if they're an employment business or whatever, or if they provide workers that go on to client sites, some of their own clients demand that they do all kinds of checks before their workers can be allowed onto the client website. And by the way, we have seen a lot of clients demanding drugs checks, which could be a whole other session, although some of the issues are the same. So it can be quite difficult because on the one hand, you've committed contractually with your own client to do these checks, but the fact that you have committed contractually with one of your own clients does not necessarily mean that you can actually run those checks on your own employees. And then of course, in terms of the sharing data piece, all the issues that we talk about all the time in relation to sharing data arise. Is it proportionate to share that data with your client? Do your own workers understand that if there's been a criminal records check on them, that data about their criminal record will be shared with your own clients? It's not to say you can't do it, but it's something certainly to think about, and to think about transparency and whatever domestic nuances there might be, because in some countries that might be prohibited. So I will go on to, so under the US Treasury Department, the Office of Foreign Assets Control, OFC administers and enforces economic sanctions. Okay, so their checks on prohibited countries and things, I won't suggest any countries on those lists, but if someone were to come to be a national of a particular country and be on a prohibited list for a US company to engage, that's an interesting one, because you might feel you have a legal obligation to do that, and therefore you'll be fine to do it. Of course, when we enter into the European sphere, it isn't necessarily good enough to say that, well, we're a US headquartered company, we have to comply with all the sanctions rules, because it tends to be, the European view certainly, is that any legal obligation that you're under must be a member state obligation. So it's quite difficult for, say, maybe Jessica will comment on this, but as an example, a German company to say, well, our headquarters are in the US headquarters are under an obligation to check Iranian sanctions lists. It's all really about the German entity. Do they have to do it? So again, not to say you can't do it. And by the way, many companies do make the choice they're going to do that because they fear a sanction from a US authority more than a potential data issue in Europe or in the rest of the world. But it's not going to necessarily be an easy global one-size-fits-all approach. So Jessica, I'm going to move on. I'm conscious I've spent a little bit of time there, but Jessica, I'm going to move on to you for the view in Germany. Thanks very much.
Thanks, Alex. And maybe just starting with a brief comment on what you just said to the second question. Yes, we do have clients who are in the, let's say, military industry, have a US headquarter, and they have the same issues. Do they provide the data they are obligated to by US law as a foreign affiliate, or do they comply with the German restrictions under data privacy? Yeah, starting with your Singapore case, as you already announced and expected, criminal records checks are very limited under German law. Can you move to the next slide? Then we can see an example. No? This is Romania. I'll keep speaking while you, Alex, sort out the slide.
I'm afraid, Jessica, that's the only German slide there is.
Okay, I'll deal with that. The criminal records, in principle, it is not possible to check any criminal records. It is even stricter than you described for the UK, Alex. It is principally only possible that the subject itself will apply for criminal records. And in the employment context, they can only be asked to do so if it is required for the role. So this is exactly what you said, Alex. It needs to be proportionate and necessary, and there are very limited typical cases where German case law would say, yes, this is necessary. Sorry, typical examples are somebody who has a huge financial responsibility, or else somebody who is dealing with small children. Those are the standard cases. And apart from that, there is really hardly any possibility to get hands on a criminal record of a future employee. So then moving to the next part of the scenario, the Singapore company wanted also to do some thorough vetting of everybody. Again, this is very limited into the extent that it's possible under German law. You would need necessity or consent to do so. The legitimate interest is usually not a legal basis in a German employment contract, in a German employment context. So what you can do, as you said, is what you call vanilla. You can verify the person, the standard data which are being listed in the CV. You can verify that he does have a legal degree of the University of Oxford or of Germany, Berlin, let's say. You can do those standard types of research. Also, you can go on people's LinkedIn or Xing. We have a German market business network, similar to LinkedIn, a bit more on the national side. And so you could go there and look what they are doing. You cannot go on private and merely private websites such as Instagram, for example. What, however, the Singapore client should do is any job recruit in Germany would typically send, by now it's mostly email, but they would send an email and they might ask, is there any interest in me? And if you say, yes, please send your full documents, then you will get a CV, you will get the exam degrees and all the references of the exams, but also written references of previous employments. And they can be really an interesting source of information. Obviously, they won't help you with any drunk party pictures on Insta or any right-wing comments on any other network, but they really are a very interesting source of information for future employers. There's a whole science around how to phrase them. They need to sound very positive, but within this positive wording, you can still hide certain descriptions, or you can leave out certain things. So there's a whole game around those written references. They are very important. Yeah, this is what you can do for vetting in Germany. So that's my part for.
Thanks very much, Jessica. So just on the point, outside a Singaporean company or mainly, US headquartered company sort of mandating and this to happen across their German entities, is it true then the culture for asking for criminal background checks or any background checks is actually just minimal? So in the domestic context, it just is not really a recognized thing that happens.
Yes, according to my experience, I would add one more thing, and this is the banking sector, especially if it is international banking. This is also, they are often trying to get consent from job recruits to be able to use vendors for vetting. I've seen that. And otherwise, mostly we get these kinds of questions really from foreign employers and often from US employers.
And how often, Jessica, though, do let's say US clients listen to what you're saying, and it totally makes sense to me, but then just make the call, we want to have a global approach and take the risk in Germany? And are there any examples of sanctions that have been levied on people? Are you aware of any, I don't know, German employment tribunal style claims where people are complaining about the processing of data in this regard?
No, I would say it's also rather unlikely to happen a lot, because obviously this vetting is being done in the background. So
Sure.
the chances of actually being caught, if it's well done, are probably not so high. And really with a criminal record, it's just a no. It's just not working unless you ask the individual to submit it. And afterwards, the individual complains, I shouldn't have been asked or so, but really, I'm not aware of any case law for that. It's
Sure.
just
And I will
something
just make
that happens in a while.
one final point. It was on one of our sessions earlier this year when we were talking about monitoring. Of course, you do have to be wary of certain of the German regional regulators. I think Hamburg with their fine of H&M for 35 million for monitoring. One never knows. That monitoring is obviously perhaps considered worse than perhaps the vetting that we're talking about now, but you just never know what kind of complaint might be made to a regional regulator.
Absolutely.
And they might hate it and they might fine you 300,000-400,000 euros. One never knows. So it's not a non-risk. Jessica, thank you very much. I will move on to Roxana now to give us the flavour from Romania. That sort of rhymes. But there you go, Roxana. Hopefully I've got your slide.
Thank you. I think it was in there. Hello, everybody. Okay, let's look quickly at the Romanian perspective. Good news and bad news. I would start with the bad news in appearance, but manageable. Vetting in Romania, it's a little bit limited because you, for example, for candidates, you cannot have vetting with anything and everything you want to put in there. You always have to keep to the need to assess ability to fulfill the position and the professional skills required in order to for which you assess the candidate. So this is a limitation under the law that you need to be aware of. How you can navigate around it, make sure that your job descriptions are pretty well written in order to allow you to go into the information on social media, education background, and so on. Information from past employers can be required, but only with the prior notice to the employee and only in respect to certain elements. So you cannot ask anything and everything about the candidate from the former employer. You have to keep it to activities and duration of employment. So if he was a candidate was sanctioned, for example, disciplinary sanctioned, that information can be very difficult to obtain. Social media and educational background, tricky. However, on social media, there is a piece of good news in the sense that the highest court in Romanian has already settled that, for example, Facebook is deemed a public area, meaning that information that you put there, even if you control access to it, to friends and so on, can actually be deemed public and therefore accessed also in the context of a recruitment vetting process. And on criminal records, we do have Article 10 of GDPR, so there are those limitations. However, the good news is that criminal records in Romania are not that generally accessible. They are managed by a public authority and can be obtained only subject to compliance with a specific law that dates back from 2004. And which specifically says that any request for the criminal record has to be justified. The practice of the Romanian authority is to give that kind of criminal records to candidates, but not directly to employers. So you cannot, as an employer, go directly to the authority and say, I want the criminal record for this person, but you can ask the employee, the candidate, to present that criminal record. However, here you have to be very careful about those limitations that have already been touched upon. So you do need to have proportionality. Legitimate interest works in Romania, but it's not credible if you end up requesting that criminal record from everybody. So that's a very important point, and actually one that has started to make its presence known in HR practices in Romania for the last 2 years, I would say. And if we move from vetting candidates to vetting employees, the bad news is that there are less opportunities to do that kind of vetting, except when you consider changing the position of the employee with a new position, when you can apply the same standards as for candidates in a recruitment process. And that's actually a challenge because in the end, you may end up being able to do more in terms of vetting for a candidate as you can do for the employee during employment. And this means that you need to manage very well how you communicate with the employees and what you put in your internal policies in terms of do's and don'ts, including in terms of behavior on social media to create that context for the verification. Now, if I were to look at the scenario in Singapore, I would say, again, vetting with criminal records for employees, it will be very problematic. Probably the authority will refuse to issue those criminal records to existing employees. So if they are not requested for beginning a new employment. And I would also say that collecting all the data from social media would be a headache for candidates as well as employees. So there needs to be some criteria in place and some clever wording. I like that, Jessica, and I'm borrowing it. Clever wording in the job description and in the policies that would allow employers to navigate this. And because I think I have 1 minute left, I will also address the question about sanction lists. We actually had a lot of practice in that, including before GDPR, where we had to notify processing to the authorities. And there have been cases where the authority has actually accepted processing of data from sanctions lists based on legitimate interest in an employment context. It was a little bit of a headache how we ended up with that solution, but the idea is it's doable, but you have to have a very strong justification cascaded down the legal obligation for the headquarters in US. For example, if you look at the US list or the sanction list that exist and are maintained by the European Union, because we have those as well. So you do have to build that legal obligation, that legitimate interest within the group, building on other legal obligations, and you have to have very strict checks and balances in place in terms of who has access to data, how it is being managed, how it is being shared, and so on.
Yeah, Roxanne, that's very interesting, and I do agree with that. And indeed, I wasn't saying just to the questioner that vetting on sanctions lists was impossible, nor sharing. It's just Roxanne has made the very good point there that you're building it through a legal obligation that's in a member state. Indeed, in the old days, just an analogy, talking about some of the whistleblowing stuff that had to come in after the Sarbanes-Oxley Act in America. It was never really a problem in the UK because we obviously had our whistleblowing legislation and it would all work, but it was very alien in France and Germany, especially. SOX just didn't really exist, and so it would cause these problems. Now I wonder with the whistleblowing directive and so on and how that's being implemented, it might be much easier, but it's all that point of trying to find a European paradigm on which you can hang what you're doing. Just saying we need to do something because the Brazilian law says we have to do it worldwide is not going to cut it. Roxana, that was very interesting. I've just got one question for you. Yep. And then I'm going to answer one question, and then I'm coming on to Tiffany in the US, so we are going to go to the US. But yep. Roxana, just in terms of the Romanian Data Protection Authority's view on this, have they given any comment on it? What is their kind of view in practice on vetting and criminal records?
I'm going to address this, and also I've seen in the Q&A section a question that I think we can build into that answer to address it as well. The question in the Q&A was whether you can ask for the criminal record just to be shown without actually collecting copies of it, and whether would that work. Now, why I say the two questions connect is because actually the Data Protection Authority in Romania is it's not the ICO. It's on the other side of the spectrum. It's very conservative. However, they took a very practical approach when it came to criminal records, because after GDPR, even if the requirement was the same before and after GDPR, they came up and clarified that for them, in order for the criminal record to fall under Article 10, it has to have certain mentions. So it has to indicate in there that the person was criminally sanctioned, and that sanction hasn't been completed in terms of rehabilitation. So a clean criminal record, they deem it doesn't fall under Article 10, and that's a nice escape in terms of being able to request that document, but just to consider how you manage it if that criminal record actually has some mentions about criminal sanctions having been applied in the past. That's huge in terms of, again, flexibility from the Romanian Data Protection Authority. So there is that element. If you keep it and if it's clean, make sure that you have different rules in place if that criminal record is not clean, because then you have to deal with Article 10. I've seen the practice that was in the Q&A asking the criminal record, viewing it, but not keeping a copy of it. For me, that's also, you can argue that it's a little bit on the minimization side, and it can build to your proportionality argument. So it can be a good solution. Anyway, criminal records in Romania are valid for 6 months. So after that, the information is deemed obsolete. So you have to have in place a mechanism to expunge the criminal records from the file after that period. That's problematic. So you can consider that, but I wouldn't shy away from actually requesting the criminal record where you can build a solid legitimate interest basis, because if it's a legal obligation, there's no headache. But for legitimate interest, you have to build the argument. And for example, in retail, if I'm thinking of the employees that are client facing, yes, I would like to know if they have been convicted for offenses that would prevent them from fulfilling their activity.
Yeah, that's very useful. But that sort of epitomizes a lot of the UK approach as well, looking at it sector by sector and retail and fraud and so on. Just I'll add 30 seconds to that question as well before coming to you, Tiffany. There's an analogy there as well with some of the European jurisdictions and looking at vaccine data. If you're shown a vaccine passport and then don't record it, you are not processing personal data. Might be an argument that one might use, but it's, as Roxana says, it goes very much to proportionality and minimization. Tiffany, I'm going to come over to the United States now, just for a few minutes from Tiffany. Hi, Tiffany.
Hello, everyone. Thanks for joining us today. In the US, although we can be laid back about certain things, criminal records are a big issue in the US. And so this sometimes prevents companies from having a global policy and the information gathered as part of the interview and vetting process. Criminal records, and that really is broken down into two components in the US, arrest records, and the federal law prohibits using arrest records to make employment decisions because it doesn't mean that a person is guilty. And so it's not permitted to be considered in hiring decisions. Conviction records, which means that someone actually did commit the crime, can be used. But there is an analysis of, is it really relevant to this job? And so usually we suggest to employers looking at each of the job positions they're looking to hire, what are the job duties, and is any kind of crime, if there is a conviction, would it be important to know for this position? So as Alex mentioned with receptionist, if a receptionist is really just answering phone calls, they don't have any access to money or accounts, maybe a theft conviction when they were 18 at a convenience store would not be relevant. Also, they suggest looking at how much time has elapsed since the conviction. And so that would need to be considered as part of a global policy. What are we looking to hire? In the US, there's also not only federal law, but there are state laws that come into play. And so there's something called ban the box. So in the States, there's a state law that says if you're having an applicant fill out an employment application, you can't just have a box that says, do you have criminal history, or have you been arrested for any crime. So that's permitted as part of the initial employment questionnaire application that's filled out. You can later down the process ask questions about convictions, but that should not be part of the initial application that's submitted. And so what you were talking about, proportionality, although that's in connection with GDPR, it's the same concept in the US. What is it relevant for? Is it relevant to this job position? The culture in the US also is really the driving force is Title VII, which is the Civil Rights Act of 1964. And so it precludes employers from discriminating against both job applicants and employees on the basis of race, gender, religious beliefs, political opinions. And so the hiring process has to be looked at, or it has to be the same process. You can't have questions that may impact one part of society more than the other. You know, if you're asking about criminal records, there's some indication that that would adversely impact maybe African Americans or Hispanics more so than other members of the population. So that's a cultural thing that has to be looked at, and looking at, is it applied consistently? Is there any disparate impact? Is it impacting one part of society more than the other as part of the hiring process? And so those are the ban the box, and then the Federal Fair Credit Reporting Act. If you as an employer are asking for information and a third party is getting it for you, you have to follow all the requirements of the federal FCRA, which you have to give the employee notice that you're requesting this information. And then once you get a report back, and if it has adverse or harmful information in it, and you're going to rely on that information to make an adverse decision, meaning to not hire, you have to give the employee notice of the report and the information in it, and give them an opportunity to respond before the decision is actually made.
Thanks very much, Tiffany. And just as a final point, and with what about social media accounts? What can you do with social media accounts in the States? Yeah,
so interestingly, some employers are asking employees for their social media password to be able to look at their account if it's not public. And in some states it's permitted, but some states have precluded ask employers for asking that. So again, it's a state by state examination.
Thanks very much. And that's, by the way, always, everyone on the call will know this, but with the states, it's not one size fits all. If you've got employees in 50 odd states, you're going to have potentially 50 different answers, and you're going to have to work through that. I will come to you. Thank you very much, Tiffany. Very interesting, as always. Renata, I'm going to come to you for just south of the United States, Mexico. Hi, Renata. I'll move on to your slide.
Yes, thank you, Alex. Hello, everyone. In Mexico, criminal records are considered sensitive personal data. So in this sense, to process this data and carry out the check, data subjects' written and express consent will be the lawful basis, unless there is an explicit requirement specified in law or it is necessary to perform a contract. It will be necessary as well to notify privacy notice, and different additional measures shall be observed, as we will see. I will briefly mention the human rights system and data protection in our jurisdiction to understand how this scenario may work in Mexico. Well, Mexico is a democratic country that recognizes human rights in its constitution, including political rights and civil liberties. In addition, Mexico is party of too many international human rights treaties, such as the UN Charter of Human Rights or the American Convention on Human Rights, among others. Also, it is important to mention that human rights are included in the international treaties are at the same level as the Constitution. That means they are at the top of the legal system. And then the protection of personal data is recognized as an autonomous human right by the Mexican Constitution in its Article 16, second paragraph. Furthermore, Mexico has acceded to the Convention to the Protection of Individuals with regard to automatic processing of personal data. That is the Convention 108 and its additional protocol since 2018. And finally, the Mexican Constitution provides guarantees and remedies to human rights. And the most important remedy is the amparo, the constitutional action. And then in Mexico, two laws govern the personal data, and for public sector and for private sector. For this purpose, in the private sector, the law that governs the protection of personal data is the federal law on protection of personal data held by private parties, which was published in 2010. And its regulations and some guidelines for the privacy notice. In this regard, we can see that Mexico has a comprehensive legislation on data protection. Then starting with the scenario, all personal data provided by the candidate or the employer to the employer and or to a third party such as screening providers shall be processed in accordance with this law. And in this sense, when processing sensitive personal data such as health status, genetic information, or criminal records, that is information that touches the most intimate areas of a data subject's life, or it is information which might lead to discrimination or involves a serious risk for data subjects if it is misused. Then when processing this type of data, additional measures must be implemented to protect them. For example, they should not be collected without justification. They must be collected for purposes that are legitimate, concrete, and consistent with the explicit objectives or activities pursued by the data controller. Now, from a labor perspective, there is no legal impediment to carry out background or criminal checks. But ideally, it should be considered that criminal records can be requested by the interested individual. That is that the job applicants will have to personally request the certificate to corresponding authorities. It is important to bear in mind that the information about detentions, criminal records, or preventive measures shall be considered as classified, and though they are not available for public consultation. Additionally, and in connection with the data protection principles, it is relevant to note that the national law on execution of criminal sanctions establishes that the nature of the position must justify requesting a criminal record certificate. Then, to the extent the above considerations are duly observed, then the criminal check should be done before the offer is made, since it is a matter of disclosing which capabilities and requirements are needed for a certain position and not as much of the applicant. Finally, I would like to mention an important precedent from the Mexican Supreme Court of Justice. In 2018, the Supreme Court issued the criteria where the requirement of not having a criminal record to exercise any activity without making any distinction or exemption violates the principles of equality and non-discrimination. These principles are established in Article 1 of the Constitution, since it will be discriminatory against individuals who have this type of record. Thank you, Alex. This will be from my side.
Thanks very much. And I'm just going to quickly, just bearing in mind time, thank you very much, Renata. That's very, very interesting. I'm going to move on to Jasper in the Netherlands just because of time. So I will move on to you, Jasper.
Yeah, thanks so much, Alex. Yeah, so from everything we've heard already today, I think it's very clear that processing criminal data, criminal records is tough to do under the GDPR. That's no different in the Netherlands. But I think in the Netherlands, we do have somewhat of an elegant solution to that, which is in the Netherlands, you can ask your job applicant to provide you with a statement of conduct. That's what it's called. And what that is something that a Department of Justice will grant an employee upon request for a job applicant. And what that means is, so the job applicant goes to the Department of Justice and says, I've applied for this job. This is the job description. And as an employer, you vouch for that. You say, yes, indeed, this is our job position that we have opened for this job applicant. And please, could you verify whether or not this applicant meets the criteria that we set in the Netherlands for these types of positions. So there's different categories of positions that it would fall into. And then the Department of Justice, they check the criminal records and they do kind of a background check on that part of the job applicant's history. And if they find nothing that would prohibit the job applicant from doing that position, then they provide the job applicant with a statement of conduct, which the applicant can then provide the employer and say, okay, there's nothing in my past that would prohibit me from doing this position, and then it's all good. And if there is something that would prohibit the job applicant from entering into service of that employer, then the Department of Justice will just say, you know, something came up in your past that would prohibit you, so we cannot give you this statement of conduct. And then that's the end of the story, basically. So then you don't have any information about the actual criminal records. You don't know when it happened, what happened, etc. You just know, okay, apparently something is in the past of this job applicant that prohibits you from doing this position, which is, I think, a rather safe way of going about things. And of course, it doesn't mean that if a job applicant has anything of a criminal record, he will never get a statement of conduct. They really look at, okay, what type of position is this? Will he work with money, for example? Okay, then there may be an issue with fraud, possibly. But if you have, for example, a lot of speeding tickets, just to mention something, that doesn't really prohibit you from working with money, of course. Whereas if you would apply for a position as a driver, then maybe that becomes a much bigger issue. So that's something the Department of Justice looks at, and they figured that out for you. And that's a pretty common approach in the Netherlands to ask your job applicants for a statement of conduct. The costs are not that great either. It's about 40 euros for a statement of conduct. So that's a pretty good solution, I think. And another system we have in the Netherlands is it's called a blacklist, which is something that is used in the retail sector and the financial sector. And to give you an example from the retail side of you, they have a blacklist which is maintained by an independent foundation. And if you are an employer in the retail sector, you can join that foundation, and then you get access to the blacklist, which includes customers, but also former employees who have either been found guilty of stealing, fraud, things like that. So if an employee in a retail sector, steals money from the counter or something like that, they are dismissed for that reason, and then they are the employer can notify the foundation. The employee is put on the blacklist. Then if the employee tries to join another company in the retail branch, then that new employer can say, hey, let's run this name through the blacklist. Let's see if it comes up. If it comes up, you know enough. It's clear, okay, he's been dismissed for fraud or stealing or something else. And then okay, that's something, that's an employee that we do not want. And that goes back 2 years. So it's not an indefinite mark on your record as an employee. It goes back 2 years and 4 years in extreme cases, but that's not often the case. And the blacklist needs to be verified. You need approval from the Dutch DPA to run a blacklist. So that's why it's only the retail sector and the financial sector until now. But that's also something that could work very well. So that's something we use in the Netherlands as well. And then to come back to the case, to the Singaporean company who wants to introduce vetting in their Dutch company. The first question was, of course, can we vet all our current employees, fixed term, part-time employees, etc.? The quick answer is no, not really. There's no longer a legitimate interest in performing a social media troll or checking the criminal records. Is just probably not possible. For the job applicants, though, it is possible. It's like I said, the statement of conduct is a very useful tool to have, and also you can look at some social media profiles, but mostly LinkedIn is the most common one. And if you want to go to Facebook, Instagram, things like that, it becomes a bit more tricky. And it's like Alex mentioned at the start, it's all about proportionality and how necessary is it really to check those aspects of the job applicant's life. And it's more common to just stick to the more business type of media, such as LinkedIn. and leave the more personal stuff alone, because yeah.
Thanks very much, Jasper. I'm just sorry for interrupting, just slightly conscious of time. There's one question for you, which I think you can answer. Just answer it in writing to Steve. But just if you give it 15 seconds before I move on to Jose for the final piece on Spain. I know you're very much into works councils yourself, and there's lots of works councils knocking around Holland. What about works councils and vetting in criminal records? Is there anything of interest there that we should know, just probably for 25 seconds, just because I'm conscious of time, so the succinct answer.
Yeah, I'll be quick. So the Works Council has a right of consent if you want to introduce or change your hiring policy. So if you want to, for example, up until now, you didn't ask for a statement of conduct, but now you think, hey, that sounds good. I'm going to introduce that into our hiring policy. If you have a Works Council, the Works Council needs to give their consent to changing the hiring policy to account for, any other steps that you may want to introduce. So a vetting process, statement of conduct, things like that. So be wary of the Works Council, because they need to be involved. Yeah.
Thank you very much. Well, Jasper, that's very, very interesting. Without further ado, last but never least, we will move on to Jose from Spain, who's got 4 minutes, and then we'll sign off. And thanks very much, Jose.
Thank you, Alex. Just briefly, as very like to the German case, as a general rule, criminal background report is the personal data, as you mentioned, is absolutely protected by Constitution. It is inside the privacy right, Article 18. Well, only two circumstances requesting to new hire employees will be possible to ask for this background criminal record. First, legitimate interest and proportionality. So the question is whether or not it's necessary to execute services to perform the contract. And second, it is a specific rule on the EU member law that authorizes, in this case, in Spain, that authorizes the employer to request such personal data. Then just specific employees or sectors, we can ask for this criminal record certificate, such as judges, the army, police, and public servants, financial entities, private security, casino employees, brokers, and professionals, as you said, and are in contact with minors, with children. There's a specific case in the Supreme Court on February 10th, 2020. In the case of private security guards, such private entities are not entitled to ask directly for such certificate to the employees, but instead what the Spanish government did was create a specific identification professional card to which entities can ask to the government and ask if they have this identification professional card of the employee. Then this is a way, an indirect way to verify if the job applicant in this case has the administrative authority, but not asking directly. And then regarding blacklist, as my colleague Jasper from the Netherlands has mentioned, they're absolutely prohibited in Spain. You cannot create blacklists in order to prevent someone else from being hired from another company. It is not permitted. And then regarding the use of social media, look out on the settings, because if the settings there are no filter and they are public, and anyone, employer, whoever, agencies, the contracts, or just they provide information to entities in order to hire employees. If there are no filters and the settings are public, then they can have access to, for instance, I'm thinking about obviously in social, like Instagram or Facebook. No password can be requested, contrary to United States. And then piece of advice for vetting employees and even for job applicants, in terms of soft law, because there is no real law creating really a social media policy in terms of what can be done and what cannot be done. Just it gives a guideline for employers and also for job applicants, I say, and existing employees, what employer is entitled to ask or not. Obviously, any information that it is not linked to the performance of the contract, it is absolutely prohibited. And that's more or less the Spanish perspective. Alex.
Thanks very much, Jose. Very, very interesting. Look, we are right at time. What I will say to everyone, although there are some underlying concepts that are similar in each country, proportionality and at least a little bit of thought about why one is doing something, I hope this session today has helped everyone just see that a blanket approach, as the scenario envisages, is a little bit tricky, and at least some thought needs to be given to at least how we might accommodate to as little or as much a degree as you wish, the domestic nuances within the territories that are relevant for you. I will say goodbye now. I think I pass over to Josabel, who's probably got some 15 seconds of goodbye to say. But thank you very much, and thank you very much to all the speakers, and we'll see you in the new year.